arbitration clauses in contracts can be helpful. China is a signatory to the New York Convention, and therefore Chinese courts will recognize an arbitration clause in your commercial agreements, and they will recognize and execute these judgments in China. The issue of how you will use your arbitration clauses are basically, you can designate a Chinese arbitration body to hear the case, or another arbitration body, for example, that sits in Hong Kong or Singapore. Now, the advantages of using arbitration is that it's less formal, costs are comparable, but just slightly less perhaps than litigation. And I think there's a little more flexibility in terms of how you want to run the case. One thing though you have to bear in mind though, if you are using an arbitration clause and you can define choice of law, it remains that there are mandatory legal provisions with respect to intellectual property, and you cannot override these provisions by designating or choosing a different law. So, for example, you could say that this contract is governed by Hong Kong law. Great, but if this contract is in contravention of these mandatory IP provisions, these provisions that are contrary to the contract law that relate to intellectual property will be struck out for being illegal, and it's possible that your judgments will not be enforceable in China. I think that many foreign companies prefer running an arbitration or having the arbitration seated outside of China in Hong Kong. The reason why being that Hong Kong has a very, very long history of arbitration, and the arbitration centers in Hong Kong are considered some of the best in the world. They're very sophisticated, they have very, very experienced arbitrators, and these judgments are enforceable in China. Also, you'll find that Chinese parties are less reluctant to be a party to an arbitration in Hong Kong, whereas if you were to name an arbitration for the United States, they might not be very keen to enter into an agreement with you. So that said, we would look at perhaps Hong Kong to satisfy all the parties. So if you're looking at a contract that is, the value on its face is only several million, it might not be worthwhile for you to run an arbitration based on Hong Kong law, because the cost will increase significantly, and it might lead a Canadian company to not even consider arbitration, although the contract, that it would be their dispute resolution that is defined under the agreement. On the other hand, if it's a smaller contract, several million, and you're going to run a case in China, for example, at CTAC, that is one of the major arbitration bodies in China, one of the largest, the idea would be that under using civil law, you would be able to run the case for considerably less. And this would provide you with a cost-effective means of dealing with the problem. So it's really important that understanding the value of your contract, if you are going to proceed by arbitration, that you define your arbitration laws, center, in a manner that is cost-effective. Otherwise, you might price out your dispute resolution to the point that you will not proceed with using arbitration, even though that is your only means of gaining some satisfaction out of the contract. Generally, what we will do is we will draft a contract that is bilingual, English and Chinese. And in doing so, both parties will have the benefit of operating or a contract in a language of their preference. In many cases, what we will also do is define the contract so that the English prevails over the Chinese. That is, if there is any conflict in the translation or interpretation agreement, we will refer to the English agreement for its interpretation in the case of arbitration agreements. If this is a contract that will be governed by litigation, the Chinese will have to prevail. This is a problem, I think, that is not unique to China. The issue of enforcement is subject to a lot of considerations, and that is, when we're looking at an arbitration agreement or an arbitration decision, the decision will be recognized by a Chinese court. That is, if you have an arbitration decision that is not contrary to the laws of China, for example, the mandatory intellectual property provisions found under the contract law, then the courts will recognize the judgment. Once the judgment is recognized, it will be handled for enforcement with the enforcement division within the courts. Now, the problem with enforcement in China, and this applies also to civil cases, is that they have limited resources. So if you are able to get a successful decision from an arbitration body or a successful judgment from a court, and the other side fails to pay, you will have to proceed to the enforcement division within the court and ask for execution of the judgment. In some cases, you'll have, in a very, very small jurisdiction, one person who is responsible for execution of all of these judgments. And with these lack of resources, it's possible by the time they come to your file, the other party has disappeared and you will not be able to collect. However, in larger jurisdictions, again, like Shanghai, Beijing, Guangzhou, Shenzhen, these are better resourced. So you have more enforcement officials involved and your likelihood of enforcement improves. So when we talk about improved sophistication of your IP enforcement agencies and the courts in more developed cities, also the execution of judgments applies, and that these are better resourced. So the likelihood of you recovering on a successful judgment or a successful arbitration decision in one of these jurisdictions is much higher than, for example, from a tier 3 city.